FEMA and insolvency law during the last month. So whatever has happened the first Friday of last month to this Friday of this month, whatever new changes has come in these 4 laws, we will discuss. The objective of the webinar is to take up the discussion, all the regulatory and legal updates, as well as the development during the last 1 month in one go. The impact of the change, any issue or complexity arising therefrom, along with participants' queries will also be taken up. All the updates will also be available in our monthly newsletter, CP Connect, which will be emailed to all the participants. We have eminent speaker for today's webinar, Mr. GP Madan, founder Law Madanche Office, and eminent task force, co-chair of SOCHM. Then we have Mr. Dr. KS Ravichandran, managing partner KSR and Company Secretary LLP, and he's from Coimbatore, spreading his wings to all over India. Then we have Mr. Ankit Singhi, Head Corporate Affairs and Compliance, Corporate Professional. Manoj Kumar, Partner, Head M&A and Transaction, Corporate Professional. Then Ms. Meeti Mangla, Manager, Capital Market Service, Corporate Professional. I welcome all the participants and all the our esteemed dignitaries for this webinar. Friends, Ankit, Meeti and Manoj, they will discuss presentation on recap of regulatory and legal updates in company securities and insolvency law. The learned panelists will talk about the issues and implication and impact. So now, and I request participants also that they can send their query in chat box. So what will happen? Ankit will take up first topic and he will give the impact. Okay, what is the law, present law, and the new law? Okay, and how this change has come, and then our expert will discuss what will be the impact of this particular law. Anything is missed out, anything is creating confusion, and anything by the government. After compiling all issues, if there is a need government change,
there is some disturbance in Pawan sir's voice. Manoj, are you able to hear it?
No, his bandwidth is low. Actually, he is not in Delhi, so yeah. I think it's connected through some mobile device or something. I think so.
So I can start the session.
Yes, I think yes, it will be better you start the session.
So okay, we need to first launch our book. I think for that, Pawan sir's presence is required. So today, everyone, today we are also launching our latest publication, that's the Handbook of Company Law Procedures. The 4th edition will hit market. It has already hit market. We will be launching the book today. Vivek, I think you need to wait. Let Mr. Pawan sir join.
I think Ankit.
Yes, Manoj.
We should go ahead with the details about the book and launch the book, because he is not able to connect. He just
Vivek, I think you can launch the book. He's there now. Sir, you are able to hear us?
Yes. So we are launching our book. So Shivam, please. Uh, uh, so this is Company Law Procedure book, and this is a book which we have come out. And I will request Shivam to give the USP of that book. What are the highlights? Shivam, please.
So this book is already in market. You must most of you have gone through it. It's a very unique, innovative product from our office that created considering the practical issues faced by professionals, corporates, and gives you access to procedures in a very easy to use method in tabular form with links to with images and a lot of other stuff for easy understanding along with the resolution. It contains more than 175 procedures along with the list of documents, timelines, draft resolutions. Procedures are not only linked to Companies Act, they also cover other compliances under Securities Standards, SEBI listing regulation, Foreign Exchange Management Act, including IBC. So generally, you find procedures which are only restricted to Companies Act. But in this book, all procedures are covered, considering almost all such compliances which are required to be undertaken for execution of a specific task. So in that aspect, it's very unique. The presentation itself is very unique in a tabular form with images for easy understanding, whether that is for approval, form filing. And then all the procedures comes along with list of documents, draft text of the resolution.
Recording in progress.
So it's a very useful book for every one of you. And I think this is a draft layout of the procedure. It gives you the governing section, regulation, the SEBI rules number, what are the forms involved, what are the approvals required under this procedure, estimated timelines, important provisions, what are the prerequisites one should keep in mind while undertaking that process. And then, as I mentioned, the details in a very unique tabulated format in terms of activity-wise provisions, what are the steps required, then list of documents required, resolutions, timeline. So it gives you a holistic picture of any procedure that you want to execute. You can find everything at just one place, and it's a bestseller among our all publications. I hope you will find the edition useful. Thank you, Shivam.
Okay, thank you, Ankit. Thank you very much for giving the introduction of book. So now, friends, I will start with because there are changes in company law, securities law, and SEBI. In securities law, SEBI has recently concluded its board meeting and they have passed various things, which we'll also discuss. Then there are so many changes in insolvency law and some prominent and landmark case law we will discuss. So the structure is simple. On company law, Ankit will start. He'll give the presentation. And then KSR will talk about the other thing, important thing relating to this. So company law, we have various changes which has taken place. Definition of a small company, what will be the impacts? CSR rules has changed. KYC directors, DIN number KYC is also, they have relaxed some rules. Then securities law, stock exchange.
Recording in progress.
Stock exchange merger. Stock exchange merger and amalgamation. There are so many things has changed. My voice is okay?
It's echoing a bit. Sir, let me start the presentation. And
yes. Yeah, Ankit, please start your company law changes. And then I'll request KSR to add value and suggest the issues. Over to you, Ankit.
Thank you, sir. I hope the presentation is visible.
Yes.
So good evening, everyone. The last month, September, is always eventful in terms of corporates, as this is the last month where everyone for holding the annual general meeting. So lots of companies hold their annual general meeting in the month of September. But apart from being the month of annual general meeting, this September was also very unique in terms of being very eventful in terms of changes in law spread across not only Companies Act but also law related to Securities Law, IBC, and various other landmark case laws was also there, which we will be discussing in today's session. So starting with Companies Act, there are a couple of key changes and that took place during the last month. So there is a concept of small company under the Companies Act, and where certain exemptions and privileges are provided to companies who fall under the category of small company. The current threshold of determining whether a company is a small company or not, there are two thresholds that one needs to meet in order to qualify as a small company. The existing threshold is of paid up capital of not exceeding 2 crores and turnover of not exceeding 2 crores. If you are meeting both the threshold, then you qualify as a small company under the Companies Act. The Government of India, by way of amendment notification, has further expanded the scope of small companies by enlarging the limits of determining the qualifications for being a small company. So now, instead of paid up capital of rupees 2 crores, the paid up capital should not exceed 4 crores, and turnover instead of 20 crores shall not exceed 40 crores. So if you are a company whose paid up capital is not exceeding 4 crores and turnover is not exceeding 40 crores, then you are a small company under the Companies Act, and you enjoy various benefits and privileges that are provided to the small companies. It is deemed as a measure for easing the burden of compliance on companies, and it appears that a large number of private limited companies will qualify as a small company on account of expansion of these threshold limits. Some of the key privileges which are available for small companies that they are not required to prepare cash flow statement. For both annual return and board report, there are average versions which are available for them. Small companies are not required to report QARO as part of the auditor's report. They can also be merged on a fast track basis under Section 233. There are a lot of forms on which there is no requirement of getting the same certified by a practicing professional. So these are some of the key exemptions which are available for a small company, though they don't appear as such, which aims to reduce the compliance burden to a larger extent, but they do provide some kind of relief in terms of compliance. I think if the intention of the government is to ease of business, then exemptions for such class of companies should also be on a higher side in terms of filings and maintenance of records. I think going forward, considering the ministry is taking small company as an important component for allowing ease of business. So we hope that there will be further exemptions that will be provided for these class of companies. So next major amendment is the all-time favorite of the CSR rules, which keeps on undergoing change now and there in terms of either by way of circulars, by way of amendments, and a lot of other stuff. So the recent amendments try to, I think, are welcome, except one or two things. First is that there is an existing requirement that if your CSR expenditure is less than 50 lakh rupees as of in any financial year, you're not supposed to create or constitute a CSR committee. Now, this rule has been trimmed a little bit, that even though your CSR expenditure is less than 50 lakh rupees, but if you have some amount in the unspent CSR account, and if you're not spending even that 50 lakh rupees in that financial year, and you've spent some amount and you've transferred some amount to the CSR, unspent CSR account, in that case, irrespective of that amount of expenditure being less than 50 lakh rupees, you're supposed to set up a CSR committee, which otherwise will not be applicable. But if you are spending the entire amount during that particular year, then the exemption continues to be available with you. Then the next amendment is with respect to CSR rules. This is a very important amendment, and this was there since long, and there were a lot of debate as to this gives a far-reaching impact and try to even go beyond the boundaries set by the Section 135 of the Companies Act, which provides that every company has to check the eligibility during the last preceding financial year in terms of turnover, net worth, and net profit to determine whether they are required to undertake CSR during the next financial year. This rule provided that if the CSR rules or eligibility is once triggered on a company, then if it has to go out of the ambit of Section 135, then for next 3 financial years, it need not to meet the criteria of one section eligibility of Section 1, subsection 1 of Section 135. Only then it will not be required to undertake CSR expenditure or constitute CSR committee. Though the section provides for eligibility to be checked every year basis your last financial year's parameters, but this section was creating an overreaching impact and tried to extend the ambit by providing that a provision will be there applicable for 3 years. If you don't meet the criteria for next 3 years, only then you will be out of the purview. This has been removed finally. So now this anomaly between the act and rules has been removed. And now every year you have to determine based on the parameters of the last financial year that whether you are required to constitute CSR committee or undertake CSR expenditure during a particular financial year. Apart from that, there are certain amendments in the implementing agencies. While the agencies continues to remain same, there were certain Section 8 registered public trust societies which were not required to obtain certain registrations under Section 12A and 80G of the Income Tax Act. Since the now CSR rules mandated these registration, even though these entities were exempted, they were finding it difficult to comply with the requirement of meeting the criteria for implementing agency. So now, in line with the requirement of Income Tax Act, where there are certain entities certain entities have been exempted from the requirement of obtaining Section 12A or 80G if they fall under these prescribed clauses of Clause 23 of Section 10 of the Income Tax Act, and they can continue to enjoy the benefits of being an implementing agency without need to undertake registration under Section 12A and 80G of the Income Tax Act. Another is with respect to impact assessment. Impact assessment, the earlier the limits of expenditure which is allowed for impact assessment was 5% or 50 lakhs, whichever is less. So the maximum amount that can be incurred was 50 lakhs. Now they have in a way expanded the limit by reducing the percentage of 5 to 2%. So it shall not exceed 2% of the CSR expenditure or 50 lakhs, whichever is higher. So companies who are required to undertake impact assessment and where the expenditure is on a higher side, that is more than 50 lakh rupees, but less than 2%, they can now easily undertake these expenditure. Or even companies who voluntarily are looking for undertaking these expenditure can also undertake this, since they now have a better leeway to spend money on such kind of reports. Another important is that annual report on CSR activities has undergone change again. Some of the notable changes are that earlier the impact assessment report was supposed to be provided along with the report if you have undertaken an impact assessment study. Now only the WAMP link and a summary is required to be provided as a part of the report, and the entire report need not to be attached. Another important thing is that which is very predominant omission, and there is also a coverage in the Economic Times today, that now the CSR annual report doesn't provide for the details of the activities on which the amount is being spent. While you, as a company, am required to provide the details of the amount spent, but the details which were earlier segregated in terms of ongoing projects and projects other than ongoing project, detailed table where you have to provide clause of the Schedule 7, area, cumulative expenditure undertaken now, expenditure undertaken previous year, implementing agencies, detail, registration number, a whole lot of details that were required. These two tables are not finding the place in the revised annual report on CSR. It's difficult to understand the reason. To me, it seems an inadvertent omission, and which should be brought back, because until company discloses where these activities on which the amount has been undertaken, it will be very difficult for the stakeholders to understand the CSR policy, the activities where these expenditure are being taken, what kind of expenditure is being taken. Then there is another small change that there were certain details which were required to be provided for capital asset in case any amount is used for acquisition or creation of the capital asset. Some details were already there. An additional detail has been added in terms of address and other things, and a tabular format has now been provided where you need to provide the details of the capital asset. These are the key notable changes in the annual report, except for few minor changes. The DIN KYC, since because of the version 3, and there are a lot of issues where people are finding it difficult to file DIN DR KYC or web form DR web KYC web. So the last date of filing the same has been extended, and now it is available till 15th October 2022 this year. That's all from me on the Companies Act, and now I request Neeti to take this forward and discuss the key changes on securities law. Thank you.
Thank you, sir. Hello, everyone. From Securities Law. Sir, should I take over the presentation?
You can put your presentation, Neeti.
Okay, sir.
Hello. Hello.
Hello, yes, sir.
नीति, अभी एक बार ना कंपनीज एक्ट पे जो चेंजेस है मैं KSR से रिक्वेस्ट करूंगा कि स्मॉल कंपनी के चेंजेस एंड द चेंजेस इन CSR, व्हाट इज हिज व्यू? KSR, प्लीज एक्सप्लेन.
Good evening, everyone.
Good evening.
I'm also on travel, and the law is also traveling. We are able to see a lot of progress in the law, and there is a responsive system, in my opinion, that is functioning to take care of the needs, and also to continuously look out for, in my opinion, ways and means of improving the ease of doing business. It's a very important, in my opinion, development in this country, that the country's the provisions, laws are being looked at to cut down the timelines, improve the efficiency. Previously, we used to, if I can add the word, ridicule the bureaucratic inefficiency. Today, we are able to see technological changes bringing about efficiency, and therefore it is no longer going to be any lack of effectiveness in getting the input and analyzing the input, identifying the input, applying the input, and also understanding levels of governance and compliances, and bring to book the people who are defaulters and compliances. Taking that forward, probably you would have noticed there was a section 56 of the Companies Amendment Act 2020, which was talking about the second proviso in section 403, which was also brought into force from 1st July 2022, as a result of which there could be higher additional fee in addition to other liability for any 2 or more occasions of defaults. That is one provision which I do not know if it was previously discussed, but I thought I'll just bring to our memory the date 1st July 2022 for the coming into force of section 56 of the Companies Amendment Act 2020, which has introduced the second proviso to section 403. Secondly, I want to move to the small company definition by increasing the threshold in terms of capital as well as turnover. We are able to see a whole lot of companies coming under the criteria of small company. So, in my opinion, a very good measure, and therefore we need to understand that accordingly. As all we have discussed about the cash flow statement not being required, the board meetings once in a calendar year, I mean twice in the each half of the calendar year, and the abridged board's report under 134, abridged annual return under section 92, the 233 facility in case mergers and all, and also 446B where lesser penalties subject to a maximum of 2 lakhs for companies and 1 lakh for offices in default, or some of the advantages small companies definitely enjoy. And therefore we need to be sure, clear. Questions which arose during the course of last a few days, I can say to 20 days, is I have already done my compliances for the current, 21, 22, and therefore whether I need to do it again, no, you are not required to do it again. Secondly, anybody who has not yet done the annual return or something, 15th September 2022 ke baad, I think they can comply with the new requirement with the increased threshold. And sometimes probably you would have seen there is a form which is known as MGT7A. This MGT7A, if you see, there is a drop down called category of the company and also subcategory of the company. In the subcategory of the company, in the drop down, you will find there is a provision for subsidiary of a foreign company. Now, if you see, there is some sort of clarity lacking, because small company by definition will not include the holding company, subsidiary company. And if you see the definition of section 2 within brackets 46 for holding company, you will find that this is an inclusive definition, says company for this purpose includes bodies corporate. Therefore, we find there are three differences. One is subsidiary of the Indian company, another is subsidiary of a foreign company as defined under the Companies Act, which means a foreign company is a body corporate incorporated outside India, but doing business in India in one form or another, and a body corporate which is not falling within section 2 within brackets 42 as a foreign company. So there is some issue with respect to this. There probably the 2 within brackets 85 should have been amended to clarify that. Unfortunately, that clarification is needed. It is lacking, but the form seems to provide a subsidiary of a foreign company also. Stopping there with respect to this small company definition, I would like to go to the other things. So if you see the form itself, MGT7A contains Roman letter 1 to Roman letter 9. It starts with the company's particulars and the business activities, the associate or joint venture category and the share capital, etc., net worth. And para 6 is not there in this form, but 7 is there regarding promoters, 8 is there regarding meetings, general and board meeting, and 9 is there regarding remuneration of directors, and 10 is there on compliances, and 11 is on penalties. So small companies, the abridged annual return, in my opinion, requires substantial change. And if I can use the platform, I would like to say that in small companies, dispute resolution is a costly exercise given the legal framework in our country. And small companies have several problems and they are getting held up due to delays in the dispute resolution. Therefore, the best thing would be a declaration that everybody, all the shareholders and directors have been thoroughly informed about the business of the company, and there has been no change in the capital or composition of board of directors or the following or the changes. So that will give a declaration in respect of small companies instead of giving so many information in several heads from 1 to 11. And the other one which I need to discuss is in respect of the lesser penalties. If you see lesser penalties, we also get reminded about certain offenses which are not coming under the adjudicatory mechanism of penalties. Therefore, there must be similar provision for compounding of offenses and other, the various other consequences. For example, I was mentioning about 403 second proviso, higher additional fee. So these are all areas where we should come with some introduce some level scales which are less than what applies to all the other companies. Then we will move to the CSR. When I saw the provisions of the CSR, we find today much clarity has been achieved by saying any threshold under section 135 subsection 1, if it is applicable in the immediate preceding financial year, automatically the entire provisions will apply. Second rule is the unspent CSR amount, so long as it is lying as unspent in the special bank account within 30 days, which money would have been transferred for ongoing projects. So the compliance of subsection 2 to subsection 6 will be continuously applicable. The removal of the second sub-rule is under Rule 3 is a welcome step. It clarifies a lot of things. And other than that, major amendments, when you see the very big relief is in the form only. The Annexure 2, which applies from the financial years commencing 2020, which means the first financial year, 21-22 is the second financial year, and current financial of projects category. It's a big thing, though Ankit was suggesting that it is required. My view is that it is a welcome step, cutting down that. Today, what the form requires is very simple. It wants to calculate the total CSR obligation by finding the 2% of the average net profits, adding the surplus, and deducting the set-off amount. This is part 1. The part 2 is it divides between unspent amount transferred to fund special account and the ongoing projects, and also the ADI. Therefore, the two divisions are brought very clearly in that. Then when it comes to unspent amount, year 1 unspent amount, year 2 it would have got reduced, year 3 it would have got further reduced. But in year 2 and year 3, new unspent amount would have got added. So that clarity is also brought in that. Apart from that, the form as such has reduced the size and the details required, and that, in my opinion, is a welcome step. And the other amendment is with respect to the agencies. Of course, the section 23C subsection 10 of Income Tax Act was not considered. I had dealt with it in my book on CSR and ESG, which is the latest book, and that is also now added in the class A and class D for the purpose of the Rule 6. The CSR form, if you see there'll be changes accordingly, and that go under the 12AA registration and all, because they are exempt under 23C directly. Income is exempt. For example, the important change is with respect to providing the total CSR obligation. Always we should see one thing: what is the amount spent actually? What is the administrative overhead spent? What is the amount spent on impact assessment? All these three things will show you what is the amount spent, and what is the amount not spent is easily found out between 5 and 6 in the form. If 5 is greater than 6 or 6 is greater than 5, though it is contradictory when you say as a statement 6 is more than 5, there is a meaning in that it will find the unspent amount. The other thing is 2% of the amount can be spent on impact assessment, and it is, of course, 2% or 50 lakhs, whichever is higher. Therefore, as a whole, when I see these amendments, I find there is a good improvement, progress is happening. And if there are some specific queries, I will later on come on. Thank you very much for this opportunity.
Thank you, KSR, for giving the expert view on this. Now I'll request Neeti to give changes in securities law, and whatever on 30th September there was a meeting of SEBI board, and they have decided various things that also please include. Over to you, Neeti.
Yes, sir. Thank you so much, sir. So moving on to the regulatory updates under the Securities Law in the last month of September 2022. So the major agenda item is the SEBI board meeting. Just a second. Yeah. SEBI in its board meeting held on 30th September took quite many decisions. We have tried to capture the major decisions taken by SEBI in its board meeting held. So one of the major decisions taken by SEBI is with regard to appointment of monitoring agency for monitoring utilization of issue proceeds. So under the current existing SEBI ICDR regulations, monitoring agency is required to be appointed in case of public issues and rights issues wherein issue size is more than 100 crore to see whether the funds for which they have been raised have been actually utilized for which it has been stated. So now the ambit of monitoring agencies has been increased and preferential funds raised via preferential issues and QIPs are now also to be monitored by monitoring agencies in case of issue size more than 100 crore, in case issue size is more than 100 crore. Since we have seen in half year 2022, almost majority of the funds in the capital market has been raised by a preferential issue. Through public issue route, approximately 30,000 crore funds have been raised, and via preferential issue, approximately 48,000 crore funds have been raised. So SEBI, I think, realizing the quantum of funds utilized, raised via preferential issue, realized the need for appointment, making it mandatory for overseeing the utilization of funds raised via preferential issues. Also, in preferential issues and QIPs, we have seen majority of the fundraising is being done towards utilization for general corporate purposes and working capital requirements. So now monitoring agencies will be appointed. They will be issuing reports on quarterly basis to the companies, and that will be placed before audit committee, and which will ultimately be disseminated to the stock exchanges by the listed companies. Further, who can be a monitoring agency? Prior to January 2022, public financial institutions, even scheduled commercial banks, can act as monitoring agencies. However, after January 2022, only credit rating agencies registered with SEBI can act as monitoring agency. So, and I think around 7, as on dates, 7 credit rating agencies are registered with SEBI. And I think, I guess yesterday Brickworks rating has been, license has been cancelled. So this again, SEBI has to check the bandwidth with regard to quantum of preferential issues and number of credit agencies registered. So this was one. Next is with regard to flexibility in process of appointment and removal of independent director. Under the existing regulatory framework, in case of appointment and removal of independent director, ordinary resolution is required for the first term of appointment and removal under Companies Act. And under existing LODR regulations, special resolution is required. That special resolution requirement is further has been incorporated last year only by the SEBI amendment. And SEBI realizes that institution of independent director is quite important plays very important role in governance standards of any company. So SEBI has found a midway, which is, I think, is one of the best governance practices. In the existing requirement of special resolution, majority is held by the promoters. But new amendment has been introduced. In that amendment, the resolution has to be set out by way of special resolution. If the special resolution, majority for special resolution is not received by the company, then following 2 criteria have to be checked. And if those 2 thresholds are met, then it will be considered as passing of special resolution. Those 2 criteria are dual, is also known as dual approval process. First is that resolution must have got requisite majority for ordinary resolution. Another is majority of minority has been received on that resolution. That is majority of shareholders other than promoters. This dual approval process was also laid down by SEBI in its consultation paper, which was issued last year. But maybe because of lack of positive consents from the industry, this was not approved. Now this has been introduced by SEBI again by way of by way of providing a flexibility to the listed companies. And this mechanism of these two criterias are being adopted by various foreign jurisdictions as well. In Israel, in United Kingdom, they adopt the dual approval process. An ordinary resolution in this case duly represents the interest of promoters. They are allowed to vote, and majority of minority duly represents the interest of minority other than promoter shareholders. So this is the another amendment which is proposed, which is approved, and it is yet to be notified. Next is approval. SEBI has approved introduction of online bond platform. In this, currently we have seen around most of the debt issuances are by way of private placement, and in private placement is done through electronic book building mechanism platform, which is provided by the stock exchanges. Under the electronic book building mechanisms, only institutional investors and QIBs can participate, and which means that there is no role of non-institutional investors in that. And our bond market is quite shining and full of opportunities. And as last year, there were around 1,400 NCDs issues which were there on private placement basis. And to provide liquidity and in last 2-3 years, we have seen various online bond platforms which are not regulated and unorganized, which have been started by various brokers like Access Yield and various fintech firms like Golden PI Technologies. They are providing their own platform, and in which most of the investors, most of the trading in debt securities is done by these non-institutional investors. Now SEBI is realizing the need and opportunities in the bond market, and they have now approved the online bond platform registration for brokers, and which will be regulated by SEBI. This will further enhance the liquidity and will regulate the whole sector. Next is SEBI has approved the reduction in face value of listed privately placed debt securities. Currently, debt securities have face value of quite high, that is rupees 10 lakh. They have approved to reduce the face value. This will also increase the liquidity in bond market. And in 2019, our finance minister has also laid emphasis on increasing the liquidity in bond market. So all these steps will move in that direction also. Next is with regard to amendment in ICDR in case of IPOs. In this case, SEBI has provided an optional alternative mechanism for filing of preliminary offer document in place of preliminary offer document in case of IPO on the main board. Currently, the companies are required to file draft red herring prospectus containing huge information about their huge information about the business of the company, future prospects, financials, and everything. And in place of on which SEBI and public give its comments. Now, in place of what SEBI has proposed, prior to filing of draft red herring prospectus, companies can file preliminary offer document which will contain curtailed information and not material price sensitive information to the public. So SEBI will provide its initial observations on that preliminary document, and which will be also made available to the public. So this will have dual impact. Firstly, it will not provide all the material information of the company to its competitors. Secondly, since SEBI's observations will also be made public, it will give investors to take the informed decision. Next is SEBI has also reviewed framework for offer for sale through stock exchange mechanism. Currently, in case the selling shareholder is the non-promoter, then selling shareholder can offer its shares for sale through open market if the offer size is minimum 25 crore and if we hold minimum 10% of the share capital in the company. Now that 10% of holding of 10% of share capital requirement has been done away with. Another is that cooling period. Cooling period is applicable in case the promoters of the company are planning to come out with offer for sale through stock exchange mechanism. Then, in case they have bought or sold shares of the company in 12 weeks prior to the offer for sale, then they are ineligible for the offer. Now that cooling period have been reduced from 12 weeks to 2 weeks. Further, one major amendment which SEBI has provided in the framework, that earlier the unsubscribed portion of non-retail investors were not allowed to be were not carry forward to the retail investors. Now retail investors can subscribe to the unsubscribed portion of the non-retail segment. Next is with regard to amendment in LODR. SEBI has already also approved the amendment in all LODR listing regulations with respect to debt securities, listed debt securities. Currently, Chapter 5 of LODR regulations deal with compliances pertaining to listed debt security. First amendment they are approved is that incorporating provisions in LODR involving a scheme of arrangement by debt listed entities. They will provide all the provisions for approval by SEBI, NOC to be required. Another thing, in case of entities other than companies, currently there is no provision in case of treatment of unclaimed amount lying in escrow account for more than 7 years. And entities other than companies can be PSUs, corporation. Now that amount has to be transferred to IPEF of SEBI. And another one is easing of requirements and timelines with regard to financial results. This is currently the companies are required to disclose the financials on quarterly basis, and in addition they have to give around the list of line items of around 26 or 27. That also SEBI has approved to relax. That's all for the SEBI board meeting. Now, amendment with regard to framework on social stock exchanges. SEBI in July has provided with various parameters with regard to with regard to registrations of not-for-profit organizations with social stock exchanges and everything. Now, they have provided eligibility conditions for registration of not-for-profit organizations which are other than financial. Earlier, they have provided financial parameters. Now, they have provided other than financial parameters. One of them is entity should be registered as not-for-profit organization under its relevant statutes, that is Trust Act, Societies Act, and that registration certificate should be valid for at least 12 months. Next is ownership and control. It has to disclose whether the ownership is held by government or it is under private control. Next is registration certificate has been obtained for taxation for these charitable organizations, and it should be valid for at least 12 months. Registration with income tax as a not-for-profit organization. The NPO should be in existence for minimum 3 years. It is eligible entity has to ensure that tax deduction is available under Section 80G of Income Tax Act, which is contributions and charity made to NPOs. Next, they have provided after getting registered, they have provided with disclosures. We have categorized disclosures in 3 stages: initial disclosures, quarterly disclosures, and annual disclosures. Initially, in these not-for-profit organizations has to file the fundraising document providing their vision, governance, social impact, and risk. And then they have to quarterly provide the statement of utilization of funds, and annually they have to provide disclosure on GGF, that is general governance and financial aspect, and also provide annual impact report. Although all these measures have been provided by SEBI, but stock exchanges still have to come out with their framework and provide all the procedures. So that's all from my side. Another amendment by SEBI, SOP issued by NSE and BSE, will be taken up by Manoj, sir.
Yeah,
Thank
Manoj,
you,
sir.
Niti.
Yeah.
So Niti, you withdraw your presentation. I'll just upload and.
Yes.
So Niti has covered the changes in social stock exchange, bond market government wants to promote, and various other measures SEBI has taken. So now Manoj, because in M&A they have changed so many new things. So please cover this part.
Yeah. Good afternoon, good evening, friends. Basically, in process relating to approval or no objection of stock exchanges, in case companies, in case any scheme of arrangement, merger, demerger involving listed company, there is a master circular of SEBI, which is November 29th November 2021, which is applicable. Over and above, to make the process simplified and standardized between NSE and BSE, and also for the benefit of all the stock stakeholders like listed entities, the stock exchanges have made us standard operating procedure. So this standard operating procedure was first introduced last year in December, but they have now further clarified certain things and brought some certain amendments in the standard operating process. These standard operating processes are very important because while filing the scheme of arrangement for no objection from the stock exchange and SEBI, companies must ensure that all the checklist issued by stock exchanges are fully complied with, and the process of approval of the scheme is also in consonance with these SOPs. So one of the these are the major aspects of this SOP. First aspect is that the valuation report. This stock exchanges have made it mandatory that the valuer who is carrying the valuation for the purpose of merger, amalgamation, or demerger should consider the financials of the unlisted company, which is not more than the company, the two companies which are involved, two or more companies which are involved, is not more than 3 months old. Basically, they are saying other than income approach, the financials should be not more than 3 months old. And the income approach, obviously, it can be the last audited financials, which is not more than 6 months old. So this is with respect to the valuation. Then it is saying that if the valuation has been carried by the valuer, the same valuation report must be placed before the board of directors for the approval at the time of approval of the scheme of arrangement within 7 working days from the date of signing of the valuation report. So valuation cannot be very old. It has to be within 7 days, not more than 7 days older at the time of approval by the board of directors. The third important aspect is, as soon as the stock board of directors of listed company approves the scheme, the same must be filed along with all the documents required to be filed for approval or no objection from stock exchange and SEBI within 15 working days. So if it is not done, then the filing would be void, and the whole process need to be started again. So 15 days is very crucial timeline. Then if the no objection document is filed within 15 working days, stock exchange would give their preliminary observation within 7 working days next. And if the queries are asked further raised by the stock exchanges, or they found that the checklist is not fully complied with, they will return the set back to the company, listed company, and listed company must rectify all the deficiencies within 7 working days. Otherwise, it will be deemed to be withdrawn. Application would be assumed to be withdrawn. The fee paid would be forfeited, and a fresh filing would be required. So, as soon as fresh filing is required, there need to be another valuation, another fairness opinion, another board meeting and audit committee and board meeting to approve the stock scheme, and then filing will happen along with all the filing fees, etc. So, it is very, very crucial that the timeline is properly met. Relating to, as I have already discussed, valuation stock exchange have already told that the valuer must consider all the three approaches, that is the income approach, asset approach, as well as the market approach while carrying the valuation for the purpose of merger amalgamation. For the purpose of these valuation, for applying the income approach, the financials should not be more than 6 months old, and that has to be audited in case of unlisted companies. And for other than income approach, the financials should not be more than 3 months old. If we are considering any merger amalgamation in the month of October, it cannot be older than August. Yes. So within 3 months, it has to be there. And if that is not there, then they will request the company to carry the valuation again. So swap ratio may get changed and everything will get haywire. So it becomes very, very crucial. Then there is another requirement which is also saying that audited financials must be provided along with the scheme of all the unlisted company, which is not more than 6 months old. So if it is a stay period after the 31st March, that has to be audited by the statutory auditor of the unlisted companies involved. And there will be one undertaking that at the time of the stock, again, at the time of filing of a scheme with this NCLT, the financials should not be more than 6 months old. So that undertaking would also be submitted along with stock exchange filing. So these are certain amendment, certain SOPs, which is over and above the requirement of the SEBI's standard of SEBI's master circular relating to approval of the scheme of arrangements. Now we will talk
Manoj.
about yeah, sir. Yeah.
Manoj, before starting the IBC, now KSR and Manoj both, what will be the impact of this merger? So KSR, I'm starting with reverse, that you just tell about the issues with SEBI is changing 3 months to 6 months, 6 months to 3 months, and certain other aspects which they are saying, and they are fixing a timeline, whether this timeline they can adhere, or whether it's a merger is becoming tough or it is simplifying. So your view, and Manoj, you also add that what will be the impact on this. So KSR, first you, and then I will request you to tell us about some securities law changes which Niti has told. So start with Manoj's point of view.
I just wanted to add only 2 thoughts here. One is there is a great degree of clarity on the timelines. There could be some problem because for some reason we are not able to adhere to the second 15 days, or after filing with stock exchanges, we are not able to rectify within the 7 days time or something. What will be the position of the valuation report which was originally approved within 7 days from the date of signing, and whether we are going to revise the scheme? Is there a case for revision of scheme? First of all, normally we know that appointed date is a certain date, and most of the schemes we have a past date as the appointed date. So there are some issues which can practically arise if we are talking about inability to remove certain observations within the specified time frame, or inability to file all the documents as per the checklist within 15 days. I don't find there is any difficulty for a corporate efficiently organizing everything and structuring it, building it in the system as a process to ensure that find any big difficulty, but clarity is not there, because in case for some reason we are not able to do within 15 days or within 7 days, what will happen to the whole scheme? What are we going to do? It's a big exercise. Corporate mergers, acquisitions and all. It's not an ordinary thing. It's a big job. In one recent case with some big this thing, when I was doing if you see the this thing, the NCLT did not agree with the dispensing with the unsecured creditors meet, even though there is no compromise or arrangement. Now we have to advise the companies involved in the scheme to go ahead with the scheme, though we preferred an appeal before NCLT. In the NCLAT, I succeeded, but unfortunately, when the judgment was issued, that was after the date of the meeting. Now, again, another 90 days are gone because to get the petition done and wait for that. So, in corporate acquisitions and mergers, we have always found timelines are the most important thing for value to be realized by the respective parties. Consideration for the scheme must be protected and preserved. In that perspective, the timeline of 7 days, 15 days, and another 7 days and all is really good. Number two is in terms of income approach, whenever valuation is done, yes, I agree with SEBI that the 3 months approach is very good because we must have the latest income levels to be ascertained. Where the methodology is other than income, yes, 6 months is chalega, or it is unlisted in one side, it is okay. Therefore, that is also a welcome step. In the result, I want to say both are good. There could be practical issues which we need to deal with whenever it comes. I do not mind forfeiture of the fees. I don't have any problem because I have defaulted, I have delayed. But it cannot be putting the clock back so much that you need to call the meet, appoint a valuer again, get these things updated, go ahead with another 6 months to say, 12 months of exercise. So therefore, timelines efficiency improvement is a welcome step, but that should not be, hitting and making it fatal for the whole of the exercise, which involves so many agencies and advisors and consultants. So that is my view, sir. Thank you.
Okay. Manoj, what is your view?
Yes, sir. So yes, it is a big challenge if in any case, due to any technical reason, there is a delay and that as per the circular, the filing is not happened, could not be done. And then as per the this SOP, scheme becomes null and void. I mean, in the sense of the swap ratio or the valuation aspect. So because actually the genesis of this SOP is that SEBI's master circular, which says that the relevant date for valuation is the date of the board meeting. So if the board meeting has to happen again, then there will be new relevant date. And if there is a new relevant, then the pricing need to be done again. So obviously it will have impact on the valuation or swap ratio of the shares because the company is a listed company. So market price would get changed, and hence the swap ratio may get changed. It may not be if the swap ratio is not beyond that number, which the negotiated number which is agreed upon between the board of directors of the two companies. But in all other cases, yes, it will get impacted, and a fresh filing need to be done. So it is a big challenge. So obviously, corporate need to be very, very careful about these timelines so that there is no dispute at a later date.
And Manoj, what about the unlisted companies, the audited unlisted companies?
Sir, that is already as part of the SEBI circular. They are just reiterating it, and that the financials of unlisted companies should be not older than 6 months, and that should be audited. So this is a challenge. Every time if the timeline in the process goes beyond 6 months from the, let's say, if we are planning to file the scheme during up to September, we can use March financials. Otherwise, we have to get the audit done for the step period. So this is already done, being done.
Okay.
As per the SEBI.
Okay, KSR, you have any comment on social stock exchange implementation plan or bond market or some other things that they have? Niti has given a presentation.
Yes, I thought, of course, Manoj, you rightly said about the another 6 months, before NCLT. That 6 months also is important. The audited financial statements cannot be older than, so you need an updated financial statement. So corporates have to work in M&A space very, very carefully if they want to go ahead with 233 or 230, 232 schemes. And if it is, of course, a BTA or a slump sale, then everything is under their control, though it will be not tax efficient or cost efficient. Coming back to the other 2 points which I thought of sharing is, as far as the NPOs are concerned, that is not for profit organizations, and so it's a welcome step. But I think like NBFC, we should have some sort of big systemically important societies raising funds only through the stock exchanges, instead of going through the donations route. Ultimately, we will see it. And as of now, the procedures have to come from stock exchanges. So we will wait for that. The second thing with respect to the independent directors is, I have a very radically different view with respect to independent directors. We are seeing independent directors as truly independent, and we have not seen any positive cases on the public domain of the role of independent directors resulting in measurable governance improvements. Wherever failures are there, we see independent directors have also failed. That we have seen, but not the positive side of it. Second thing is, as a matter of fact, independent directors are supposed to be neutral, not aligned with investors, not aligned with promoters, not aligned with minority shareholders. Therefore, the minimum majority of minority shareholding should have been a 3-class minimum majority. 1 class is the minimum majority promoter voting, minimum majority investor voting, minimum majority minority shareholder voting. With this 3 minimum majority, with a 51% to overall majority, I think that would have been radical view. Thank you. That much only I want to say now. Regarding OFS and all, I'm okay.
Sir, there's one question. What is the minority definition in appointment of ID?
Minority holding is supposed to be, in my opinion, removing the promoter holding and pure public, not indirect public.
Okay, so in case there's a institutional joint venture, what will you do?
I do not want it to be clubbed with a minority public shareholding. It is definitely not acceptable because they are institutional investors. They have their own ways of pushing things and their own ways of collecting information. They are wherewithal, their meets, analysts, investors, gathering of information, getting guidance in advance. All these things are not there on minorities. So minority shareholding, when SEBI said in this particular subject of independent directors, I really feel it means the pure public minority investors. Like what you say is retail. No, we saw retail can participate in non-retail. So that retail segment is what I should connect it.
But sir, presently the position is that other than promoter, all are considered to be in minority for
the purpose. Yes, except other than promoter, everybody is public float. But I want to differentiate between public float and a pure minority. In fact, I have suggested 3-class minority, majority of voting, promoters, investors, and pure minority. All 3 classes majority must be achieved. Total majority should be achieved because an independent director cannot be in the office when somebody is not happy with him, promoter or investor. We don't want an independent director to be enjoying the support of promoters or only investors and all. We don't want such a person to be appointed, or such a person also should not be taking up appointment when he is not seen as a person required for the paramount interest of the company. That is antithetical to independent directorship. That individual should have it instead of getting cleared by one single majority. That individual, if I were in that position, promoters do not vote for me, why would I sit there in the board?
Sir, so that protection is already there because it is a dual test. One is simple majority. So obviously it is assumed that promoter have substantial stakes.
But shareholding pattern will change, no, sir.
Yeah. So simple approval, majority approval would be there, in which promoters' view would get captured, and then again it will be majority of minority. So it will be capturing the views of the public category shareholder other than promoters. Obviously, differentiation between retail and institutional is difficult.
Very difficult. KSR is giving a new dimension. So we will see that something new will evolve. KSR, you have any other view on securities law changes?
One thing I saw was that minimum holding period is not there in OFS. We are talking about 20 crore and we are talking about removal of that 10%. But
Yeah.
my opinion is there is how valuation was a major subject in recent times, particularly after the what you can call it as unicorn and startup. Similarly, we are completely aware that in equity, private equity investors के लिए, for the purpose of exit, IPOs are done, which in my opinion is not going to be a pure IPO. There will be some sort of articulation, manipulation, and whatnot. Therefore, in OFS, I would prefer, it is my personal view, a minimum holding of 3 years should be a criteria in addition to this 25 crore. Of course, 10% is removed is fine. I don't want to stop anybody from participating in OFS. But minimum holding, a person in order to be an offerer in OFS, in my opinion, shall at least be a person holding that stock with him for at least 3 years. I mean, that is not there now. I am just adding that criteria. That's all. Thank you.
Okay. Okay. So now, so we have covered the Companies Act, we have covered the security law, and the security law we have covered merger also. Now over to Manoj you for changes in insolvency law. And what I'll do, Madan will be the expert to give comments, and KSR can add value wherever he requires. So you take up one changes and Madan will react, then you go to second one. So over to you, Manoj and Mr. Madan.
So yes, I think I would like to have valuable inputs from Madan sir whenever it is he would feel. So first amendment is very small amendment but very important, which is relating to fast track in corporate insolvency resolution process. So all as per the present law, any startup as defined by DPIIT would be eligible for fast track corporate insolvency resolution process. So presently the timeline earlier was from the date of incorporation up to 5 years, they would be considered as eligible startups for this fast track corporate insolvency resolution process. Now this timeline has been extended up to 10 years because the DPIIT has already amended the law. So this is just one part. I think if Madan sir would like to add something, or what are the benefits or something like that?
No, nothing is, no comment from my side.
Okay. So second one is I think there are various changes which IBBI has brought to make the insolvency process more robust in India. So first one is just for information purposes. They want that insolvency professionals should intimate IBBI all the cases, all the matters where they have been appointed as insolvency professional and the matter has got stuck or is pending before any high court or the Supreme Court of India. Then that need to be intimated to the IBBI. So this is just information purpose so that they can collate why certain matters are getting delayed due to litigation aspect. So this is for information purposes. They want IPs to intimate.
Manoj, on this, it's not a small amendment. Actually, this is a circular issued by IBBI to insolvency professionals.
Right.
According to me, this circular should have been applicable to IRPs, RPs, and liquidators. But unfortunately, this circular is applicable to insolvency professionals.
Yeah.
And as per the definition of insolvency professional, any individual who is registered as insolvency professional, registered with the IBBI, enrolled with IPA, and registered with IBBI is insolvency professional. So if a particular IP is not having any assignment, how can you report? Number one. Number two, if you read this circular minutely, at one stage you will find it is advisable, it is advised, and on the other hand, you will see it is mandatory on the part of the IP to report this.
Yeah.
Actually, all this is nothing but the outcome of this rainbow paper and Vidarbha Industries.
Vidarbha Industries.
Because their IBBI has not been a party, and the Supreme Court has passed certain orders without IBBI being a party. So taking a cue from that, I think this, instead of giving a circular to IPs, according to me, IBBI should strengthen its own legal department. And wherever the cases are pending, the legal department should, the duty of the legal department to intimate internally to the board.
Yeah, sir, but actually it is very difficult. There are many cases, many matters which goes to High Court sometimes, and tracking all the High Court's real-time basis may be a difficult.
It's very easy. Manoj, in our office, if my staff can do it, I think IBB legal department can also do that.
Right. So yes, whenever
let's move forward to whatever the deficiencies according to me were there. I have given my observation. Yeah.
Right. So now IBBI has proposed to fix certain minimum fee slab for insolvency professionals being appointed as interim insolvency professional or insolvency RPs, resolution professional. So they have made a threshold minimum threshold of 1 lakh rupees per month to be the fees of insolvency professional, irrespective of the size of the company going under insolvency. There has been many of the cases where insolvency professional were not paid, or there are cases where they have been paid very exorbitant amount. So they want to intervene here and want to fix the minimum fees, which is 1 lakh rupees. And up to 5 lakh rupees. Even the COC, considering the size of the case or effort required, or they can increase this 5 lakh rupees to any higher amount. So this is, I think, it has a dual side effect. Obviously, this is a commercial aspect, so regulator may not intervene in fixation of the fee because there may be various considerations. But for many of the small insolvency professional, it could be a very good relief, because many of time at least interim professionals could not get even 1 lakh rupees sometimes. So that is the case. I think Madan sir can give the practical views here.
Yes, Manoj. Now my apprehension, this minimum, actually the wording used in the regulation is minimum fixed fee.
Yeah.
And in my view, the committee of creditors will remove the word minimum and will keep it as a fixed fee.
Yeah.
That's number one. Number two, here regulation is silent on what will be the fee for the period commencing from date of filing of the application for approval of resolution plan or liquidation till the time disposal of this application. I'm sorry, the regulation is not silent. Regulation is talking about that. And you know, this period from the date of filing of the application, approval of the plan or liquidation till the time disposal of this application, it is taking not less than 2 years.
Right.
And for this period, there is no minimum fixed fee, and the regulation provides that the committee of creditors shall fix up the fee now. This is very unfortunate part, and according to me, every committee of creditors would be of the view that during this period, there is no work for you to be done. So please, we are going to pay you minimum peanuts. There may be 25,000 or 50,000 or whatnot. And RP will not be in a position to say no at this stage. He will not be in a position to resign. And he will be bound by the dictate of the committee of creditors. In my view, the regulation should have been that the minimum fixed fee shall be payable from the date of commencement of CIRP till the date of disposal of the application for approval of the plan or liquidation, as the case may be. This entire period should have been covered in the minimum fixed fee. You know, by the time this plan, by the time this plan is up, this is KSR, I think you're on mute. You want to say something?
No, you finish it.
Okay, yeah. According to me, I just forgot what I was saying. Yeah, according to me, the moment the CIRP period finishes, by this time, there are a number of litigations, number of cases pending against the company, against the CD, against the RP. And that is consuming a lot of time and energy and resources of this RP.
Right.
Now, during this period, the RP has to preserve the asset. He has to maximize the value of the assets. He has to take care of all the stakeholders. He has to do all the compliances with them. The company is listed. He has to do compliances with SEBI and stock exchange, blah, blah, and whatnot. And if the company is a going concern, you think it from that angle. If the company is a going concern, is his RP's work is going to be lessened? Answer is no. So this minimum fixed fee should have been there at least for this period also. This is my observation.
Right. So obviously, sir, this is a big challenge. Yes, in many of the cases, litigation and matter keeps going on for any longer period, and in that case, no fee is payable. So if this minimum fee level is minimum fee payment is extended till the approval or disapproval of the resolution plan at NCLT level or passing of order of liquidation, then there will be a lot of pressure over NCLT also to dispose of the matters as soon as possible, and COC would be more interested to close that process.
No. You please don't worry, and see, there will not be any pressure on the adjudicating authority. Don't worry about that.
Yeah, obviously, and adjudication authorities are not bound by anything, any timeline or any cost aspect. So, another amendment relating to fee, they have now. Earlier, only in case of liquidation, there could have been success-based fee. Now they are bringing this success-based fee concept in insolvency resolution process also. So they are saying the performance-linked incentive fee can also be given to insolvency professionals, which should not be more than 5 crore rupees, and it will depend upon the performance, which is timely execution or timely filing of the resolution plan before adjudication authority, or maximization of value up to at the rate of 1% of the amount, which is more than the liquidation value, realizable value more than the liquidation value. These decisions need to be taken by the committee of creditors. So I think this is a welcome move, and it should be encouraged.
Yes, Manoj.
Yes,
yes, Manoj. This 5 crores is going to remain in the regulations only. It will never be a reality. Let's be clear, because and I'm saying this on the basis of my experience. Number 2, if you read this B, for value maximization at the rate of 1% of the amount by which the realizable value is higher than the liquidation value. Now, what is the realizable value? Is it the resolution plan value, or the payment which is being made to the secured financial creditor, or is the payment being made to all creditors? What is the realizable value? And what will be the realizable value in case of real estate project? Suppose there are claims of 1,000 crores of rupees, and now the project is 90% complete. And now the RA is coming, and RA is infusing only 100 crores rupees.
Right.
If you see the plan value will be to the tune of 1,100 crores of rupees.
Right.
So what is the realizable value in this case? Will it be 900 crores, 1,000 crores, 1,100 crores, or 100 crores only? And in this scenario, the liquidation value will be much higher.
Right. So in that case,
that clarity is to be provided. And what do they mean by realizable value, particularly?
I think we will realize it when it comes.
Yeah, we will realize when it comes. Yeah, next point.
KSR wants to say something, Kaman.
No, I just wanted to say that the practical experience is between the date of plan approval to the, date of presentation of the resolution plan after approval by COC to NCLT. Actual approval at NCLT is suffering due to various reasons, best known to us. And that takes sometimes months together. So during that period, payment of fixed fee or higher fee will be a big difficulty for the CARP cost, and particularly in the case where home buyers are involved, and if they are the creditors forming the creditors. So there are some situations where we need some leeway. The current prior to this amendment, the COC had the power to fix it according to the needs. Sometimes there may be preservation, protection, cases, litigations, and so on and so forth. Sometimes there will be nothing. There will be only turned, and they are waiting for the approval of the COC approved resolution plan by the NCLT. So I think that once you are COC approves the resolution plan, from that time to the actual 31 approval, I think COC should have the correct leeway. They will take the decision, because in some cases when we requested the RP reduce the fee from 10 lakhs to 5 lakhs per month, he says until NCLT approves, I am going to charge the same fee, though there is no work. So it depends on facts of the case. So therefore, the right thing will be to leave the COC with the discretion to decide that. That's my view. Thank you.
Sir, I think Madan sir has rightly said it will be leaving things to the mercy of the COC. Maybe some challenge. Yes, it is both side true. What you are saying, sometimes there is no work, and still RP is charging a lot of money, which is reducing the value for value realization for the public COC members or other creditors. But on the other side, if COC is not accepting anything, then it will be very difficult for the RP to survive, because they cannot refuse, because their name is there, so they have to appear before NCLT every time.
Manoj, I think there are so many amendments. We have to move fast.
Yeah. Okay. Yes. So besides that, I think two simple thing is there. Simple clarification that the fee of RP can be paid out of the fund available in the company, or it can be through contribution from the members applicant or the member of committee of creditors or interim finance. These will be considered to be the insolvency resolution process cost. So it will get priority. Another thing is
Manoj, yes, only thing we need to remember that all these amendments with respect to the payment of fee to the IRP or RP shall be effective to all the appointments effective on or after 1st of October 2022. Yes, this we need to.
Yeah. So last one is simple thing which is already there in the law, that IP should not accept or share any fee or charges with the professionals or service providers being appointed during the process. So that is a correct thing to reproduce. Then
no, Manoj, there is one confusion here.
Yeah.
What will happen sharing of the fee with the IPE? That clarity is not there, rather it has created the confusion.
Service providers. So is it service provider for the CIRP process?
Yes. According to me, they should have provided a clarity excluding IPE, where this IP is a partner or director.
Okay.
Yes.
Now there are a few other amendments which is intended to maximize the value realization under the insolvency resolution process. So first is one basic major amendment is that now RPs and COC can decide to float another option. If the first EOI fails, then they can float another EOI in which there can be sale of one or more assets of the company, and if that is very important. And another thing is, in such case, there will be a process provided. What will happen if the asset, after the main asset is sold, what will happen to the rest of the company? So it is not there right now, but they are now providing this part sale of the assets of the company even during the CIRP process. I think this is a welcome move. I think.
No, Manoj, sorry. This is absolutely wrong drafting of the regulation, according to me. You see here what the regulation is providing, that if there is no resolution plan, resolution professional shall issue another RFRP. To whom? To whom RFRP shall be issued if there is no plan? It should have been another Form G. It should have been another expression of invitation of interest, invitation of expression of interest, not RFRP.
Not RFRP.
No,
yes.
but it's not. Cannot be RFRP. It is absolutely wrong drafting, and I have already brought this to the notice. Manoj, please. You can't read it like that. I've already brought it to the notice of IBBI.
Okay.
That this should be amended. So this is not a welcome move. This is a wrong move.
But if it is expression of interest, then
I can understand. It means you are reopening the entire case. I don't mind that.
Right.
But if you read this entire amendment, this is for sale of the assets of the corporate debtor, either all the assets one by one. Is that the objective of CIRP? Sale of the assets. The objective is sale of the CD, sale of the business of the corporate debtor, not sale of the asset. The company is not into liquidation. Suppose there are 10 assets, you are able to sell 2. What will you do with the rest of the 8? Will you apply for liquidation for the rest of the 8?
Provided by the resolution plan applicant, na? So that
no, my dear, here the resolution applicant is giving a plan for that asset only, not for all the assets.
No, they will also provide the treatment for the remaining assets. So that is
to be provided. How can that be possible? Treatment of all the assets. He'll say that I'll sell all the assets. Is the company going into liquidation? Again, that is my question.
No, that is the biggest challenge. That's why it was not provided earlier.
No,
but there are cases where there were dispute, there were requirement that certain assets need to be disposed of during they were not connected asset, and one of the assets or the company there were interest for those companies, but certain assets were such that there was no person who is going to buy entire thing. So now they are providing opportunity to sell certain part in first go, and the balance can be acquired by the resolution applicant. So sometimes some kind of restructuring, demerger type of slump sale is also envisaged in this.
No, I don't agree with this at all, because it can be sale of the units. If there are 5 different units, 5 different projects, you can sell one by one project. You can't sell the asset. It has to be business, it has to be unit, it has to be project, because there are certain real estate projects, and I have seen there are certain orders from the adjudicating authority.
Manoj and Madan, there are so many amendments, so we have to be fast now. Time is short, so please.
We have one option: either we cover all the amendments in a hurry, or we cover.
No, Madan, we have to.
You take a call, please. You take a call, please.
So we have to cover both the things, both the points, combination of both. We have to cover also, and we have to discuss also.
Okay, so another thing is the circular also says that COC to formulate a strategy for dissemination of information so that wider target audience can be, or potential resolution applicant can be tapped. So that there is a higher success rate of insolvency resolution. Another thing is they are saying that the preferential transactions related application must be filed on or before 130th day of insolvency commencement date. So this is also a very important thing, because in many of the cases, the resolution professional file the preferential transaction, reversal of preferential transaction or other transactions at a very later date, and their outcome is not known to the resolution applicants. So now they are saying that the application must be filed and their content must be disseminated or informed to prospective resolution applicants so that they can make account of those while filing their resolution plans. Then there is a change in the timeline for submission of information memorandum, which need to be filed on or before 95th day of the insolvency commencement date. Earlier it was 54 days. So 54 days was found to be very short period for RPs to gather all the information for proper information memorandum. Now they are saying that it will be up to 95 days, 95th day. They can gather the information and make a proper information memorandum. Then information memorandum should contain information relating to operation of the corporate debtor, financial statements, contingent liability, geographical coordinates of the fixed assets of the company, so that sufficient information is available for the applicants. Another thing is they are also saying that the business evaluation should also be provided in case the asset side is more than 100 crore. So in large size cases, there should be proper business evaluation report, which can be gathered by the insolvency professional from third-party agencies and can be circulated to all the prospective resolution applicants. And then, yes, sir. Sorry.
Yeah, my observation on this, I think it's going to be very, very taxing. If you see first 30 days are there for a constitution of COC and holding of first COC meeting, then you have to go for valuation, and then you have to go for transaction audit or forensic audit, and on the basis of that, normally this application is being filed.
Yes.
I have my own doubt whether during this 130 days, this can be completed and application can be filed. And secondly, if you see the Rainbow Papers Limited judgment by Honorable Apex Court on 6th of September 2022, the judgment says that all the timelines under the code are directory and not mandatory.
Yeah.
It says under the code. It doesn't say under the regulations.
Yeah.
Code includes regulations also. Even all the timelines have been declared to be directory in nature.
Yeah.
This will be a big save. And actually, tomorrow, if you don't comply with any of the timeline, and IBB issues show cause notice,
Hello, sorry, voice got broken.
Yeah, there's a phone inside. I'm saying every time now, if you receive. I'm sorry,
Manoj,
but
you-
somebody's calling me.
Yeah, sorry. So,
move,
sir,
move to next slide, please.
yes, sir. So next one is relating to in case the company goes into liquidation, there is a requirement that some committee of creditor may say that even during the insolvency liquidation, companies a compromise or arrangement can be explored, and that mandate is given to the liquidator by the committee of creditor. So now the amendment says that COC should decide this at their last meeting whenever they are recommending the liquidation, and they should explore the possibility of merger, amalgamation, or any kind of scheme of arrangement or compromise even during the timeline where the matter is pending before NCLT. So this will reduce the time. This will give ample time for any prospective company or applicant who can be part of the compromise or arrangement. So without waiting for the final order of liquidation from the adjudication authority, committee may keep exploring the possibility of merger, amalgamation, or any kind of scheme of arrangement. This is also a good thing.
It is no doubt a good thing. Actually, as per the regulation, it's not only COC, but COC and RP both have to explore the possibilities of this compromise arrangement under Section 230.
Right.
Number one. Number two, for last 4 or 5 years, I think this all started in 2019, beginning through a judgment of Honorable NCLAT in Amit Gupta case and S. Dhanpal case, where the possibility of 230 in liquidation was to be applied. But till date, no clarity has come that who can submit this scheme of compromise or arrangement. If you read Section 230, it says the compromise arrangement scheme can be submitted either by the shareholders or by the creditors. But in reality, if you see, the liquidators are coming out with the announcement in the advertisement in the newspaper, and then they are inviting this scheme from anybody and everybody on this earth, that anybody can give this scheme. And that is not the objective of the law, according to me. Because if it's a scheme under Section 230 and of Companies Act, and 230 talks about scheme from creditors or shareholders, not from anybody else. That clarity is to be provided. And number two, whenever such a scheme is submitted, the scheme of arrangement or compromise is submitted, after submission of the scheme, which act will be applicable, whether it will Companies Act or IBC, with respect to the meetings and voting. Clarity has not been provided so far.
Yeah. So yes, that is a big challenge, and whether in this stage also shareholders' approval would be required. So that need to be.
Yes, sir. You can tell us. Madan is saying clarity is not there. You have any view on this?
Yeah, I just wanted to say two things. One is with respect to the previous matter of submission of request for resolution plan. Once again, the amendment has been thoughtfully made because we are on the one side discussing about providing longer time for expression of interest for wider dissemination. And therefore, the sale of assets or units or undertakings in the sort of hiving off or demerger is only for all the prospective resolution applicants are already enlisted. And during the discussion on the resolution plans or negotiation, there would have been a reasonable understanding of what is the saleable side of the assets for a business purpose as a going concern and what are the surplus assets. So my point is that I think it has been carefully drafted as giving request for resolution plan for sale of one or more assets, which of course the understanding is the undertakings and units. The second, coming to the second point of waiting for the liquidation order, and during the period of waiting time, you are thinking about scheme of arrangement or compromise is a step in the reverse direction. Because after a lot of public transparent publication and procedures, resolution plans are invited and the provisions are made for expression of interest to resolution plan, evaluation matrix and whatnot. Therefore, the question of bringing some compromise within the 30 days or while waiting and all is not a correct thing. Let us go by a clear waterfall. Code applies, resolution plan is sanctioned, or a liquidation is ordered. In liquidation, we go for whatever is required. And that is how it should be actually. And in the name of scheme, there are any number of cases where value realization has been totally against the maximization of value as a laudable objective of the code. which practically you study, you will get it. That's all.
Sir, here it is saying that in case COC is already recommending the liquidation of the company, in that case, and they want to explore the possibility of a scheme of arrangement or compromise, then they can start exploring the possibility till before adjudication authority approves the liquidation. So it is only in case of liquidation is decided, then only it is. If there is a scheme of, if there is a resolution plan, then there is no question of exploring the possibility of a scheme of compromise or arrangement. So I don't think.
Manoj, clearly let us understand. COC has recommended liquidation. It files an application. It is waiting for order of liquidation. Now,
Right.
why did the COC approve the liquidation, recommend the liquidation? Because there is no resolution plan.
Right.
Nothing is possible. Right. You have gone through a big procedure to understand that there is no resolution plan possible. And therefore, within that period of 30 days or few days when your NCLT is sitting on liquidation, I mean, a passing order of liquidation, what is the great scheme that you are for? Which interest are you trying to serve by introducing this provision? I'm not able to see. Let the liquidation be ordered, liquidator take charge.
In first 45 days, there can be a possibility of any scheme of compromise or arrangement. So
that is after liquidation order is passed.
Nothing more than that.
That is after the 2 weeks after liquidation. My view is I don't want any provision for introducing something during the waiting period. That is not a correct view, is my view. Okay.
Okay. Yeah. So now another amendment is relating to the liquidation process. So now, right now, after the liquidation order is passed, liquidator becomes the sole authority to manage the affairs of the company under liquidation. Later in past, there has been one amendment through which stakeholders consultation committee was introduced for the purpose of advisory to the liquidator. Now they are extending the role of the this stakeholders committee, and they are saying that for the first 60 days till the time committee of this stakeholders consultation committee is formed, the committee of creditor would act as SCC. And their role will be more similar to COC than just a consultation process. So they can appoint or they can remove the liquidator, they can fix the fee for the liquidator. All those things has been introduced. I think this need a lot of discussion. What is the purpose of this and whether it is good or not. So I think views of Madan sir and KSR sir would be good here.
Madan is there or not?
Yeah, I'm absolutely here.
Go ahead. You are the first choice. Always.
Yeah. You know, this is I think it's a welcome move. Only thing is that they have provided clarity. Otherwise, the constitution of SCC was taking time. Now they say first 60 days COC shall act as SCC. Then they have actually enhanced the ambit or the area of jurisdiction of this SCC, but the role still remains advisory. And even the constitution of COC, now more stakeholders are there in the SCC. But there is one confusion has been created now. Earlier, it was being provided in, I think, 31A, Regulation 31, if I remember correctly, of liquidation regulations. It was being provided that how many nominees shall be there from each category. Now that has been totally been replaced, and the now new regulation is absolutely silent. And how many nominees will be there from each category? And that is going to create confusion. Suppose there are 10 FCs, whether all 10 will be having only their representatives or only one will be there on behalf of all 10. That clarity has not been provided. That is creating confusion.
Okay, KSR. Okay, next move. Manoj, next. Yeah, KSR, your point?
Then I wanted to say that, you know, when we are talking about COC and SCC, claims are already ready. After all, during CARP period, there will be only updating of the claims, a few cases. The resolution of dispute relating to claims would have happened. Therefore, the COC itself cannot become the SEC for the 60 days. On the date of liquidation, whatever is the admitted claims, basis that with due representation to all the stakeholders, SEC should be formed. To say COC will be the SEC for 60 days and the admission process will be completed by liquidator, I don't find much difference because the claims are already admitted and thereafter the RP was in charge during CARP, the whole management. Therefore, there could be some adjudication of disputes by adjudicating authority relating to claims, and that's all. Thank you.
Yes, sir. Though I want to respond to this, Mr. Pawan will not be allowing me to reply.
Yeah, Mr. Madam, Mr. Manoj, next point.
Yeah, sir. So next is also very relating to the liquidation process only. So whenever the COC decides that the process of compromise arrangement may be explored during liquidation process, the liquidator should file application only in such cases before NCLT for considering the proposal if within 30 days of the order of liquidation, they get something. So there has been a certain event-based timeline has also been stipulated relating to auction process under the liquidation. So I am not going into the detail of the process here. I think.
But Manoj, according to me, there is some overlapping. On the one hand, it is being said that within 30 days, no compromise arrangement shall be filed. And I think another resolution provides that liquidator shall try to sell the CD as a going concern during first 90 days.
First 90 days, yes.
So whether so 90 days period will start after the expiry of this 30 days or both the timelines will run concurrently?
I think 30 days should run concurrently. I think they don't want 30 days first should lapse and then...
It can't be possible. Now, on the one hand, compromise arrangement, on the other hand, sale as a going concern. Both the things can't be possible.
Okay. So before filing the application for dissolution or closure of the process, SCC shall advise the liquidator the manner in which proceeding with respect to avoidant transaction or fraudulent transaction or wrongful trading transactions should be pursued by the liquidator. So this is also provided.
Sorry, Manoj, please come to this again.
Yeah. Sorry.
You tell me if there is any avoidance application, a certain amounts are to be received out of this avoidance application.
Yeah.
How can SCC decide how this amount shall be distributed? It has to be distributed as per section 53 only.
Right.
There cannot be any second mechanism. SCC cannot take a call on this, how this amount shall be distributed.
It is not relating to distribution, it is relating to pursuing those cases.
No, my dear. If you read the entire regulation, it is for distribution also.
So that is a by law act will supersede. So obviously distribution will happen.
But why to have such regulation which is creating confusion?
It is mainly because there was confusion that who will pursue those cases and how it will be done. So that is the only thing where IBBI could have made any law. So they have made, I think by default, the word distribution would have been inserted here. But the purpose is how to pursue those cases.
Who shall pursue the application is a welcome step.
Yes.
But if they decide to distribute, not welcome.
Obviously, distribution cannot be beyond the section 53. Yes.
53. Yes. Please.
Yes.
Manoj, next.
Yeah. Sir, so another is IBBI is now would like to charge fee from based on success of the resolution plans. So they are now calculating the regulatory fee, which is now much more than existing. So they are saying the regulatory fee of IBBI would be at the rate of 0.25% of the realizable value to the creditors under the insolvency resolution plans. So that will be paid to the IBBI. And a regulatory fee of 1% of the cost being booked by insolvency resolution process cost would also be paid to IBBI. So all the agencies who have been appointed during the CIRP process, their fee collectively, 1% of their fee collectively need to be deposited with IBBI. I don't know whether it will be deducted as a tax or something and then deposited, or it will be over and above the fee which is already paid by the approved by the COC and paid as CIRP cost. I don't know. That clarity is not there, but yes, they are asking for the fee. So there will be substantial income for IBBI to make them independent.
Yes, coming to this first amendment, 0.25% of the realizable value. Again, my query is, what is the realizable value? Number one. Number two, levying of this fee on the successful resolution applicant. I am one of the culprits who gave this suggestion to IBBI. But my suggestion was that you levy this fee on RA, but please don't levy any fee on insolvency professionals. But what is the outcome? They have levied the fee on RA 0.25%, and they have enhanced the fee from IPs from 0.25% to 1%.
Yeah.
And then not only his fee, now what they are saying on the fee payable to the professionals also.
Yes. So lawyers and other
now the question is whether it will be deducted from the fee payable to the lawyer, or it will be cost to the CD.
It will be cost to the CD apparently.
If it is cost to the CD, it means you are going to increase CIRP cost now.
Yes.
IBBI itself is going to increase CIRP cost. That's not a welcome move.
Right.
This is my observation.
Now, okay. Yeah. So last amendment is that now insolvency professional agency entities can be appointed as insolvency professionals for any corporate resolution process, insolvency resolution process. So obviously fee part is small, but the thing is, in case of large size corporate, individual insolvency professional may not be capable enough to monitor, to manage the affairs and to realize the maximum value. So now they have realized this, and they are now allowing IPEs to get registered as act as IP insolvency professional for large size corporates, and they can act as a body corporate. So this is a very, I think,
इसमें मेरी एक apprehension है मनोज जी इसमें.
Yes, sir.
Suppose this IP is appointed as a IP, IPE is appointed as IP.
Right.
But certainly IPE will designate one of the IPs to act as IP. Tomorrow, if any disciplinary action is there against that IP, and his or her license is cancelled, or his registration is, or license is suspended, or registration is cancelled, will it amount to suspension or cancellation of the license of IPE also?
So it is not. I don't think this will be the case. They are saying that yes, you have to. The application or any process would be signed by one of the director or partner.
Abhi Manoj ji, this needs to be discussed in detail. Today we can't discuss. This is a very serious issue, and they are being discussed and deliberated amongst the IPs.
But KSR and Madan, what will be the impact of this change? Will it improve the quality? Will it improve the resolution process? Or there will be faster process which we expect? Or what will be the total overall impact? KSR and Madan both can give answer.
My view is very simple. It has been actually talked about for last around a year also, that slowly and gradually all IPs will be wiped off and only IPEs will remain. And that is.
But it is a welcome move, or it's not a good move?
From resolution per CIRP point of view, no doubt it's a welcome move, subject to further clarifications.
KSR, you have any view on this?
Yes, globally there has been a lot of discussion on individual liability versus corporate liability. India is now experimenting the new system. We have studied several case laws where negligence and fastening liability on individuals, and they are introducing probably a limited liability concept. And the straight answer whether it will improve the quality or efficiency, I doubt, because after all it is direct personal action by the individual professionals carried through the name of an agency. So this provision by itself is not going to bridge, but it will only probably help in taking the necessary risk to run the show, because there could be limitation of liability coming to help of the individuals comprised therein. That's all.
Okay. So I think this move is good, because what will happen, individual person has a limitation, and when they were taking help, then the law are coming in between. So I think it is a best way that you can have a big firm and they can do work. So I think we have covered all the points, and whatever questions we have received, we have discussed that point also. So this is a time that whatever changes during this month has come, all points we have discussed threadbare. Friends, in case you have not you are not able to write to us today, or you are not completely satisfied, or your point is not answered, or this discussion has created more some new doubts, you can write to us. We will give answer with the help of our experts, or we will write to the regulator. So thank you very much. Thank you, my all learned speakers, and special thanks to KSR that while traveling, he's positively attending without any sound, without any noise. That's a commitment he has done. So thank you, KSR. Thank you, Manoj. Thank you, Madan sir. Thank you, Niti. And thank you, Ankit. Everybody has covered their point. And this program structure, we are planning to modify certain things, that from next time onwards, one will be the anchor, one will be the critical, and we will call the regulator also. So the point is that first anchor will discuss about the factual things, and the critical issues will discuss by the other expert. Why, what will be the impact, whether it's a positive, negative, and negative, what are these things? And then we will take the view of regulator, that why they have brought out this law, and if there is a confusion in interpretation, he can clarify the doubts. So that way we can make this program and this updation more effective and more value added. So thank you very much to all, and thank you my all learned speaker, and especially my all participants, those who have participated in this program. Friends, this journey will continue. So next Friday on 14th, we are discussing on a very interesting topic, and people have demanded so many times, demystifying Prevention of Sexual Harassment Act, that is called POSH. So we are discussing threadbare this law, present position, impact, and the case law recently relating to this. And we are calling those who are expert in this, those who are doing practice in this area, and we will discuss all issues. If you have any query relating to POSH, you can send it to us, and we will take up this in the next webinar. Thank you very much. Thank you all.
Thank you.